Welcome back. Now, the Information Regulator has imposed a hefty administrative fine of 5 million rand on the Department of Basic Education. Now, this following the department's failure to comply with an enforcement notice that was aimed at protecting student privacy under the Protection of Personal Information Act, or POPIA. At the heart of this issue is the publishing of matric results in newspapers, a practice the regulator had ordered to stop. Today, we delve into the details of this landmark decision and what it actually means for both the department as well as the class of 2024. To further expand on this, let's now extend a very warm welcome to Adv Pansy Tlakula. There, she's the chairperson of the Information Regulator of South Africa. Advocate, season's greetings. Thank you so much for your time today. Please firstly outline all the factors that actually led to this decision and ultimately the 5 million administrative fine towards DBE.
Thank you very much, Alicia, to you and your viewers, and happy holidays to everyone. What happened is that the Information Regulator conducted an assessment to determine whether the manner in which the Department of Basic Education processes personal information, particularly as it relates to the publication of matric results in the newspapers, whether this complies with the provisions of POPIA. And during the assessment, we came to the conclusion that their processing doesn't comply, particularly with Section 11 of POPIA, which provides that anyone who processes personal information can do so without obtaining consent, consent of the data subject, if they can prove that processing protects the legitimate interest of the data subject, in this particular case, the learners, or processing pursues the legitimate interest of the responsible party, in this case being the Department of Basic Education, or that processing is in compliance with an obligation in law. So we found that these three grounds of justification for processing without consent do not apply, because the department failed to prove to us that those three grounds apply. So we then came to the conclusion that since they could not prove the applicability of those three grounds, then they have to obtain consent of the learners who are above the age of 18 before they publish their matric results in the newspapers, or the consent of the parents or guardians of the learners who are below the age of 18.
Now, the response from the department, advocate, is that they responded well within that prescribed 30-day period after receipt of the notice, right? And they've also filed an appeal, which means your enforcement notice then becomes suspended, and have also vowed to release the results in the media. So what happens then if they go ahead and release the results? We will be having them, talking to them shortly after your interview with you.
Well, let's start with whether they complied with our notice within the time that we had prescribed in the enforcement notice, which was 31 days. The 31 days expired on the 19th of December. As at 5 o'clock on the 19th of December, we had not received the court papers from the Department of Basic Education. We only received their application where they were actually challenging our enforcement notice. We received those papers on Christmas Eve at around 10 o'clock in the morning, which was outside their time. By that time, the horse had bolted, and we had already served them with an infringement notice. We served the infringement notice, I think, on the 23rd, if I'm not mistaken, or on the 20th. In which we find them 5 million rands for non-compliance with our enforcement notice.
And then what happens,
so
advocate?
The next step...
Yes, please go ahead, advocate.
Yes. Yeah, no, we're taking legal advice because we are only served on Christmas Eve. So as we speak, we're taking legal advice from our lawyers on the next step.
All right, and there's, Advocate, there's been long talks or conversations about the need for reforms of this process and manner of how these results are actually released, due to specifically the fact that there has been concerns about the mental health of those that don't particularly find their names on the list, leading to suicides in some cases. Has the department even presented any alternative means to you, like the schools being the custodian of said results?
Well, you see, with us, we are not even looking at those other social aspects, of the consequences of publication. We are simply concerned with whether publication complies with POPIA. That is why we are saying that they must obtain consent. If parents give consent that the matric results should be published in the newspaper, we are fine with that. However, I think the issue that we have to put on the table is the issue that says that the results are anonymized, because that is one of the issues that the department, put forward, because only the student or examination numbers of pupils or learners are published in the newspaper. And we have looked at this quite carefully, and we found that those numbers, the examination numbers, are sequential, and that the learners sit in that order sequentially in the examination room, and the results are published in that order, which means that if you're number one and you're sitting in front, I'm number two, I'm sitting behind you, I can be able to see your results on the newspaper, because I will know that your examination number is 1 and mine is 2. So that's not complete anonymization, because students can see each other's results. So that is why we feel that consent is necessary. If parents don't have any problem with giving consent to the department publishing the results of their children in the newspaper, so be it. That's what our concern is in this regard.
Advocate, thank you so much for your input this afternoon. That is Advocate Pansy Tlakula there. She is the chairperson of the Information Regulator on their battle with the DBE to not publish the matric results on newspapers.